Justin Combs and Cuba Gooding Jr. just got a major legal win. They have been removed from a lawsuit filed against them by a main Sean Combs accuser as the rapper stands trial for sex crimes. We're talking about Rodney Lil Rod Jones' lawsuit and what the court says his attorney did wrong that ended up with Justin and Cuba Gooding no longer on the hook. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Major update for you in one of the early cases in the Sean P. Diddy Combs legal saga concerns Rodney Lil Rod Jones. Haven't talked about him in a while. This is Combs' reported former producer on the Love album. We've talked about him extensively here on Sidebar in the past. Jones originally filed a lawsuit against Combs and other people like actor Cuba Gooding Jr., Combs' purported chief of staff, right-hand woman Christina, Combs' son Justin, corporate entities. He first filed the lawsuit in February of 2024, then amended it later that year, and he claims a number of things. He claims he was present for a shooting that Combs and Justin were allegedly a part of. He was allegedly subjected to unwanted touching of his private area by Sean Combs. Says that Sean Combs would walk around naked, that he tried to groom and entice him into homosexual sex, that he was sexually assaulted by others in Combs' orbit like Cuba Gooding Jr., that he was coerced into commercial sex acts, sex trafficking, that he sued for various causes of action, including violations of human trafficking, racketeering statutes, essentially the allegation that Combs operated a criminal enterprise. Well, guess what? The case just got tossed out for both Justin Combs and Cuba Gooding Jr. For now, I'll explain. But first of all, what were the accusations against Justin and Cuba Gooding Jr.? Well, first of all, with Justin Combs, Jones alleges that he was present at Chalice Recording Studios out in LA when this argument breaks out between Sean Combs, Justin, and a third man known only as G. Now, Jones says that he heard gunshots ring out, sees G lying on the floor bleeding, says Combs and Justin exited, they disappeared, implying they were behind this traumatic and chaotic violent event, and also claimed that Justin solicited prostitutes, underage girls, sex workers, that he would engage in the infamous freak-offs, as federal prosecutors have alleged in Justin Combs' father's case. These are the elaborate coerced sexual performances. So Jones sued Justin for violation of RICO, racketeering, pattern of criminal activity, as well as sex trafficking, because Jones claims he was sex trafficked. When it came to Cuba Gooding Jr., Jones claims that while on Combs' yacht, Combs tried to pass off Jones to actor Cuba Gooding Jr., who was on board. Claims the actor touched him, groped him, fondled him, sued him for intentional and negligent infliction of emotional distress, sexual assault. Now, Diddy, Justin Combs, Cuba Gooding Jr., they've all denied the allegations, with one of Combs' lawyers, Sean Hawley, previously stating that they have, quote, overwhelming, indisputable proof that his claims are complete lies, meaning Rodney Jones' claims. So before we get into what happened with these two now being dropped from the lawsuit, I want to bring in trial attorney and federal litigator Alexis Rosenberg to talk more about this. Alexis, so good to see you. Thanks for taking the time.
Thank you for having me.
So before we even get into what happened with them being dropped for the case, just overall, what do you make of the allegations that were asserted against Justin Combs and Cuba Gooding Jr.?
Well, there are a lot of allegations which you just outlined. But, recently there was the motion to dismiss, and a lot of those were dismissed out. So we really don't have the RICO anymore. That's gone. We don't even have the breach of contract. That's gone as well. So we're really left with some limited. We have the Trafficking Act violation still standing, some premise liability, and the sexual assault. So that complaint has really been gutted. But what is also interesting, it appears that a lot of the other defendants, not just the two you mentioned, are no longer part of this case. Now, based on the fact that they filed some voluntary dismissals, we could kind of guess maybe they settled, but we don't know for sure.
Hey everybody, this is another Law&Crime legal alert. Did you know that children are being diagnosed with serious conditions like type 2 diabetes and non-alcoholic fatty liver disease, and the research is potentially linking ultra-processed foods to this? Yeah, well, Morgan & Morgan is stepping in to fight to hold these food companies accountable. With decades of experience fighting large corporations, they are ready to stand up for the families who deserve justice. So if your child under 21 has been diagnosed with type 2 diabetes or fatty liver disease, then visit www.forthepeople.com/food or scan the QR code on screen to learn more. So recently, Judge J. Paul Oken agreed to dismiss the RICO allegation because it wasn't properly established the connection between Combs and his, alleged racketeering enterprise or criminal conduct and activity, and Jones allegedly not being paid for his contribution on the Love album. In other words, how was he affected by this alleged racketeering activity? The court said the court cannot identify any such causal link. Defendants' alleged sex, drug, and gun trafficking activities did not foreseeably or naturally preclude defendants from honoring their recording contract with Jones. As we just talked about, the judge also dismissed trafficking claims against the Combs global corporate entity, emotional distress claims against Combs, breach of contract claims. Alexis, does this signify a weakness in the case? Does this signify problems in how it was properly pled by the lawyer in this case? What do you take away from that? Because to have it gutted, as you said, is quite significant before you even get into why the claims against Cuba Gooding Jr. and Justin were dropped. We haven't even talked about that yet.
Looking at it and looking at the order from the court, it does appear to be pleading issues. Also, what was very interesting in that order from the court on the motion to dismiss, the judge, really scolds the plaintiff's attorney. I have not actually seen in a federal order for a motion to dismiss a judge scolding the plaintiff's attorney openly in that manner. So I found that very interesting, where he says blatantly that and actually says that if you continue in this manner, there's going to be sanctions. That the way he pled that complaint, in the judge's opinion, was inappropriate.
Actually, let me pull it up. So Judge Oken told Tyrone Blackburn, so lawyer for Jones, that due to his, quote, unsettling conduct he was concerned about, that issued a warning. Blackburn's filings are replete with inaccurate statements of law, conclusory accusations, and inappropriate ad hominem attacks on opposing counsel. Yeah, I haven't quite seen that either, and it makes me wonder, we're in the middle of, we're about to start the Sean Combs criminal case. From pretrial filings, it seems to me there might have been a discussion about Rodney Jones being a part of that case, maybe was interviewed by federal prosecutors, but it also seems to me, based on these filings, I'm reading between the tea leaves, that he is not going to be called as a witness, that potentially his claims couldn't be properly verified, that maybe that's why he's not being called. We don't know for sure. I remember reading a filing that said producer one, the defense was talking about producer one. I made the argument could be Rodney Jones, but given the problems in this case, does it seem to you unlikely that he would be called as a witness in Sean Combs' criminal case?
I agree with you, Jesse. And also, I think that they have tons of other witnesses, it appears, that can go and set up and testify to the elements that they need in that case without calling him. It does seem a little loose. And also, we have somebody who is participating. So I agree. I don't think they're going to call him.
I'm about to get into Justin Combs and Cuba Gooding Jr., but real quick, did you feel that the claims, racketeering, was just too broad of a claim for this kind of civil lawsuit?
Well, civil racketeering, I defend civil racketeering cases, so that's not unusual. But I do find it interesting that it seems from the pleading that he really, meaning the attorney, missed some major points, because some of the points about the predicate acts and what you can and cannot have are very clear case law, which are the judge cited in the order. And the plaintiff's attorney really should have done a little more research to make sure that those acts, but it could have also, not that there's any accusation by me on the plaintiff's attorney, it could have also been made for the news to give it teeth, to get it into federal court. There's various reasons to make that racketeering, cause of action.
So now I want to get into what happened here, with Justin Combs and Cuba Gooding Jr. So again, the judge here, Judge J. Paul Oken, United States District Court Judge for the Southern District of New York, issued an order yesterday. And I'm going to go through it piece by piece. So in the order, the court explains that it granted Jones' previous request for an extension of time to serve Gooding and Justin Combs with the papers in this case, but Jones apparently missed the deadline to serve and then didn't ask for an additional extension. Now, apparently, Jones now is asking the court to serve them in alternative ways by publishing in 2 newspapers. So Alexis, talk to me about that. How does that work exactly? When would it work for you to publish the notices in a newspaper? How does that work?
Well, first of all, this is federal court. So you can't just disregard notices, deadlines, court orders. Federal court is very strict about that, and anything you need to ask ahead of time, not after the fact. So first he got an extension, then he missed the deadline, then he turned around and asked that if he could have permission to alternatively serve them. Now, what's interesting about this is, what is the problem here? I'm not getting, this is just service. You have 90 days initially in federal court. Why didn't he try to follow the procedure? Because we're talking straight procedure. Why wasn't the straight procedure followed to get this service? That's my big question. Now, filing publication, it is a route you can do, but you have to follow the procedure of the initial ways that you're able to serve the defendant prior to seeking alternative service, which, based on the pleadings, was not done.
I'm going back to my civil procedure class back in law school, but I remember it briefly a little bit. But how would it actually work? So you publish your complaint in a newspaper, which newspaper, so that the defendant would see it? Is that how it works exactly?
Well, alternative service, you have to do attempt to do the appropriate service that's listed in the rules of procedure.
Yeah.
So, which they didn't. That's why there was that hearing that showed up where the judge said, first it was a letter, tell me why, what's going on? Why haven't you had this individual served? Then you can seek to do alternative. One alternative is potentially publication. But you have to show good cause for that.
Sure.
And you have to show why the other appropriate means of service were not done. Yeah. They didn't do that. I mean, the pleading says they didn't do it. They acknowledge they didn't do it.
Let's talk about that. So the rules say you start with personal delivery or a combination of mailing and delivering to a suitable representative at a person's home or business. If you can't do that, that's not possible. Nail and mail service is allowed. That doesn't work. Service can be made how the court directs. So this is what the order from the court says. Quote, regarding Cuba Gooding Jr., Blackburn provides documentation of attempts to effect service at 3 addresses in California. Blackburn sent a process server to the 3rd address only after the November 8th deadline had already passed, stating that the process server received the summons from Blackburn on November 10th, 2024. Despite previously claiming that he, quote, attempted to serve Gooding in New York, Blackburn provides no documentation of any such service attempts. Blackburn also did not attempt to serve Gooding in Florida, despite acknowledging that similar attempts were successful in other cases. Nor does Blackburn provide evidence that nail and mail service is impracticable. Alexis, let's start there. What do you take away from that?
I think that the attorney has a problem. Why wasn't this done? But also remember that this was dismissed without prejudice. And so that means that they can turn around and refile potentially the complaint or include them and try to get appropriate service and follow the procedure. Now, I don't know if they're going to do that based on the order on the motion to dismiss and other things. They may choose not to do that, but that is an option, and they have to do that within the statute of limitations.
Can Blackburn, Rodney Jones object to this, appeal this decision to dismiss the case against Cuba Gooding Jr. for failure to serve? Can they appeal that, or this is the end of the road for them? They have to now figure out what they're going to do next.
That's not appealable. No, they wouldn't be able to appeal on that. Also, it's not a final because they're allowed to. They have leave to, or they're allowed to file again. So that's not an appealable thing. The question is whether they are going to refile against those 2 defendants and then try to appropriately get them served.
I'll get to Justin Combs in one second. Just any rationale for why this happened or why they didn't provide, according to the court, documentation of the service attempts? Anything you can see about why that might have happened?
I don't know, maybe it was office failure, miscommunication. I'm not sure. I mean, this is just kind of a simple thing. You file a complaint and you get service and you stay on top.
It is a simple thing, right? It is a simple thing. It's not the hardest thing in the world.
No, it's not the hardest thing. It's pretty simple. So, and it's not even an attorney thing, really. It's generally office staff. So I'm not sure. It just seems because they missed the first deadline, that's understandable. but then they get an extension and then they don't do anything. So I'm leaning towards just some sort of office failure.
Okay, well, that's concerning to say the least. So now let's go to Justin Combs. The court writes, quote, regarding Justin Combs, Blackburn provides a transcript of his correspondence with a process service provider showing that attempts to effect service using a process server began on October 19th, 2024. Blackburn first provided the process server with 2 incorrect addresses. Blackburn then provided a third address at 7:46 p.m. on November 6, 2024, 2 days before the deadline. The process server attempted to effect service the next day and confirmed that, quote, subject resides at the address, but, quote, was unable to access the address due to private gate fence. That afternoon, Blackburn correctly instructed the process server to leave the summons and complaint with a security guard at the property if unable to reach Justin Combs himself. However, despite Blackburn's instructions, the process server responded later that day that service to the security guard or front desk personnel will not be accepted by your court. Blackburn did not respond that day. The process server again attempted service the next day, but did not leave the papers with Justin Combs' security guard. The process server so informed Blackburn, but despite the November 8th deadline, Blackburn did not respond until November 9th at 3:46 p.m. At that time, Blackburn reiterated that service could be made by leaving the summons and complaint with a security guard and told the process server, let me worry about the court rule and you worry about serving the documents. Blackburn and the process server continued to argue, and at one point Blackburn changed the service location to the address next door without explanation, but the papers were never left with a security guard or otherwise delivered to Combs' address. Wow. Alexis, what do you make of that?
I agree with you. Wow. Okay. First of all, the process server is correct. The security guard, I'm going to assume, does not reside at that house. So, you're not going to get service that way. The big thing that's glaring is he's doing this without notifying the court. He could have easily filed a motion and said, the addresses that we had before, we couldn't get service. We now have before the deadline. The key in federal court is before the deadline. We now have this new address that we're going to attempt service. Can we have an additional extension? The court doesn't have to give it to him, but generally, if you explain those circumstances, they will give you an extension to try to affect that service. But the fact that this attorney is arguing with the process server pretty much knows what is going to be appropriate and inappropriate service. And then I have no words for the address next door. So I don't know about that, Jesse.
Was there anything other than notifying the court? Is there any other way to serve a party like this? Because Justin Combs is very different than John Smith. Might live in a mansion, might have security guards. What is an alternative method here that could have been done? Or is it just, listen, tell the court what's going on. They could have given you an alternative way to do this.
Well, no, it's not an alternative way. First, he should ask for an extension because it seems like he was trying to effect service after that deadline, which is problematic. But the alternatives, there's a lot of people that live in gated communities. He's not the only person that lives with a gate. So the alternative could have been, if they couldn't get personal service, they could get him at his place of employment. Or they could have done what you mentioned early, which is referred to, mail and nail. So there was other options, but they had to be completed before that deadline, or they needed to notify the court that they needed more time to do it. I think that he was going under, states are a little more lenient with that, but not federal court. The federal court, those judges run their courtroom. You need to follow those deadlines. They're not playing. And if you, for some reason, need permission, it's not simply an agreement with opposing counsel. You have to, even if you have that agreement, you have to get approval from the court. I think that's where it went downhill.
So then the order continues in sum. For both Gooding and Justin Combs, Blackburn waited until the service deadline was imminent to make meaningful efforts to effect service and then failed to notify the court or request a further extension when his efforts failed. The court therefore determines that plaintiff has not shown good cause for failing to serve Gooding and Justin Combs as required by Rule 4M of the Federal Rules of Civil Procedure. Accordingly, plaintiff's motion to effectuate service by alternative means is denied, and plaintiff's claims against Gooding and Justin Combs are dismissed without prejudice. We talked about that. The clerk of court is directed to close the motion at docket number 91 and to terminate Cuba Gooding Jr. and Justin Combs as parties in this action. Now, Alexis, that was the appropriate remedy here. That was the appropriate action by the court.
I agree with it. I agree with the opinion of the court. I think that this attorney, and it really is the attorney, it's not like the plaintiff understands or even probably knows this is going on until he had to call his client and say, guess what? They're no longer part of this lawsuit, which I wouldn't have wanted to be on the phone for that conversation. But I think you have to follow the rules of procedure.
And what do you expect is going to happen next?
I'm leaning towards that they're not going to refile against these two defendants.
And that's a big win. That's a big win for them, right?
Well, remember, even if they file against them again, they still have to get past, I'm assuming they're going to file a motion to dismiss. A lot of the other allegations were, as we discussed earlier, dismissed. They have to get, and then even if they get past the motion to dismiss, they have to prove the case. So, it looks like we talked about earlier, that there were a lot of defendants, that there were voluntary dismissals filed by the plaintiff. That leads me to believe that they settled. So that may have been the intention to start with of this plaintiff, to get the people to settle and not really have to litigate and prove the points.
It's just a fascinating update in this case as we now continue on with the Sean Combs legal saga, as we continue on now with his criminal case. We wanted to bring just an update as to what was going on, because this is one of the bigger lawsuits that we saw. It actually was one of the first lawsuits that we saw. Now Combs is facing just dozens and dozens of lawsuits. But Alexis Rosenberg, thank you so much for coming on. It was great seeing you, and thank you so much for taking the time.
Thank you for having me.
And that is all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.